The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding.
Thank you, Madam Clerk. Good morning, councils. Will the clerk please call the case?
This is Supreme Court case number CRA21-010. The People of Guam, Plaintiff Appellee versus Muki Joseph Redhart Callahan, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Peter C. Paris. Appearing for the Plaintiff Appellee is Attorney Mary Ann Woloshuk. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Paris reserves 15 minutes.
Mr. Paris, you are recognized. Please proceed.
Good morning, Chief Justice Carbolito, and may it please the court. On appeal, we ask on behalf of Mr. Callahan that all charges against him be reversed and that the convictions be vacated. We've raised three substantive issues on appeal. First, there was insufficient evidence upon which to convict Mr. Callahan on all of the charges involving KRF. The burden of proof was on the Attorney General to prove 7 penis-vagina penetrations and 7 penis primary genital contacts, and the jury must have agreed unanimously as to the specific instances of each. In this case, the government called 6 witnesses. Based upon the evidence presented, it would have been impossible for the jury to have convicted Mr. Callahan of these 7 instances of penetration and contact, and it would have been impossible for them to find unanimously. The reason being as follows. Number one, witness number 1, Ms. Stanley. The bulk of her testimony was hearsay, and if we exclude her hearsay, then she testified to no penetrations and no contact. When we look at witness number 2, KRF, she said that it was impossible to testify how many times it occurred. And as to, she said more than 10 times, but it was of non-specific conduct. She talked about oral, she talked about penis, she talked about hand, but she was never able to testify as to how many instances. MJT, witness 3, testified to 0. Officer Cruz, if we exclude his testimony as hearsay, it would be 0. If we take his testimony as to KRF, it would be 1. Valerie Cepeda, witness 5, testified to 0. Amparo Rios, witness number 6, said KRF said more than once, but did not specify a number. Based upon this evidence, it would have been impossible. There was insufficient evidence for the jury to have convicted him of those 7 instances of penetration and contact.
So, Mr. Paris, in these circumstances where we have generic testimony, as you referred to more than 10 times, you have a minor child who is allegedly abused. You have a resident child molester, allegedly. And your contention is the testimony from, in this case, an 8-year-old and a 5-year-old must be in reference to a specific time, place, and circumstance. And will there be any time when such a incident in which involving a very young minor child and someone who there is a trust relationship, will that person ever face criminal prosecution if your contention is there must be testimony as to specific acts? Are you contending that the minor has to keep a diary in order for the alleged child abuser to molester to be criminally prosecuted?
No, but I am saying that the government, looking at it objectively, in any case, the government has the burden of proving each of the essential elements beyond a reasonable doubt. And if the government, based upon its evidence, cannot establish because they're dealing with an alleged minor victim, to 10 instances or 7 instances, but they can as to 1 or 2 or 3, then they should indict as to 1, 2, or 3, and not to 7 or 10. I think we have to look at this objectively rather than have than having an adjustable standard based upon the position of an alleged victim. Defendants have rights. those rights are protected, and the burden of proof is on the government. So it's not a matter of, I understand that there are challenges when you deal with minor victims. That is a government issue, not a defense issue.
What about when the government's argument, and in this case, the indictment tracks the statute in terms of that it must be done intentionally, and in terms of the time period that it occurs and the place, and they track the statute in the indictment, and the evidence on the part of the KRF child victim here, whether the indictment alleges 6 incidents of of penetration, and one other instance on 2 specific times in 2 places, one in Jigo, one at the base, and the argument that she testified, first of all, in terms of the specific acts or the acts of more than 10 instances, and that if the government is able, and if it comes down to a credibility issue, do you believe the child or do you believe the defendant, that it occurred more than 10 times, that if they're able to, the jury's able to believe the child victim here, that then they're able to reach a unanimous verdict that in reference to the 7 instances of penetration and contact, because 10 is more than 7.
I understand, and I'm not arguing it's a credibility issue, because that would be for the jury to assess. I'm arguing it's a sufficiency issue, and even when we take the evidence in the light most favorable to the government, what does KRF say? She says it's impossible to say how many times. Jury cannot speculate. They're instructed not to speculate. So if it's impossible, how is the jury supposed to come
Well,
to
it's
a
impossible to specify the specific instance and the specific number of times, but more than 10 is certainly more than 7. And that there is certainty. If you believe if the jury believes the victim in this case.
But Your Honor, more than 10 of what? Because she said he raped her. This means intercourse. Intercourse means oral sex. And she doesn't remember if she told her mother how many times. He put his penis in my vagina. He made me do oral sex. It's impossible to testify how many times. More than 10 times of unspecified conduct. Is she talking about oral? Is she talking about hand? Is she talking about penis, vagina penetration? That's what they have to prove. And that's the problem in this case. And, you know, I think, you know, these cases are difficult because nobody wants a child to be victimized sexually. But at the same time, no, we need to hold the government to its obligation to prove the case beyond a reasonable doubt. And in this case, looking at the evidence in the light most favorable to the government, and their 6 witnesses, their main witness, the victim, says it's impossible. So if she says it's impossible, then how does the jury make a determination? They're either speculating, or they aren't doing their job. Even
under your theory, I mean, I understand your argument about when she talks about performing oral sex or putting the penis in the vagina without specificity as to which incident occurred. There's at least each incident occurred once. So you're not alleging that he should be, that the evidence was insufficient to convict him of all charges, right?
Well, the jury, let's, if I take that further, what did the jury agree to? Which instance? Because they have to they can't just agree that the statute was violated. They have to agree to which specific part of the statute, which instance. This is a 6th Amendment constitutional right to a unanimous jury verdict, which is extended by the Organic Act of Guam. Ramos versus Louisiana Supreme Court says this right applies to states and federal trials equally. And the 9th Circuit says you cannot have more than a conclusory agreement. The defendant violated the statute in question. There must be substantial agreement as to the principal factual elements underlying the specified offenses, and they must unanimously find the government has has proved each element beyond a reasonable doubt. So which instance? The government, in its argument to the jury, did not say, look at this specific incident at this time. How can you have jury unanimity with such non-specific evidence? And I understand the government's argument that, and I understand we're dealing with children witnesses, but still, these are the standards. And I submit to the court that these standards have not been met. And if anything, send it back for a new trial. And
let me ask this, Mr. Paris. I know it's not your job to help the prosecutor in reference to how to do their job, but in these instances where you have a resident child abuser, sexual predator, and you have victims who are very young in age, in this case 5 and 8. So, and I don't think you agree that I don't think you disagree that you don't want to immunize, create an immunity for this type of conduct, that it can never be charged. So I just want to go back to that they should only have charged one incident of sexual act and be tied into the time, place, and circumstance of this one incident at each location. Is that how would this work under your theory that the defendant here can never not face a criminal prosecution, but it's just the way that the government charged it in this particular circumstance?
well, Your Honor, I don't think it's a matter. I'm not saying that that a person like the defendant in this case is immunized. I'm just saying there are standards. And one way to do it, and the AG's job is not to get convictions, it's to see that justice is done. And sometimes justice is done by being selective in the way in which you prosecute. So if you don't have the evidence to prosecute 7 instances, the way it was indicted here, but you have an alleged victim saying that it happened one time, he put his penis in my vajayjay one time, and you're specific about, and you've got that specific testimony, base your indictment on that. Because in this case, the government overreached and they charged more than they could prove based upon their witnesses. That's how.
Yeah, but in the facts of this case, as I understand it, I mean, the child victim here was not able to testify as to a specific time, place. I think the circumstance, she's able to do that in reference to his penis being inserted into her vagina and touching her vagina. So I think that circumstance she's able to describe, but the specific time, it seems that you're suggesting that she must say that on a date certain, it occurred on this specific date at this specific time at this location, and not just that it occurred at the Jigo home, but you seem to suggest that it has to be more specific, so that the jury can all then agree that this specific act occurred on this date at this place.
Your Honor, I'm not trying to argue that it needs to be quite so specific. In this case, one way the government could have established the one instance would be to say it happened within a specified time frame, and in the indictment, in the third amended superseding indictment, there are 2 relevant time frames, and they're based upon where the alleged victim lived. So, they would be able to establish Guam. They would be able to establish the defendant. They would argue intent. They would argue a penetration, and they would argue that it happened within a specified time frame. But in this case, and if they had presented the case in that way, in a clean way, in a fair way, in a specific way, then they probably could have obtained a conviction that was based upon sufficient evidence where a jury could unanimously agree. In this case, they throw 7 different charges of penetration and contact against my client without substantiating it. I'm not saying it needs to be overly technical, And, you know, I don't want to be misinterpreted in that way. I'm just saying there are elements that must be met, and the government has the burden of proving them. And if they don't, you know, it's even more unfortunate, I would say, in a child victim case. But it's also, we also have to look at defendant rights. When somebody gets accused of criminal sexual conduct against a victim, you're almost automatically convicted in the court of public opinion. Everybody looks at you differently. Your opportunity to redeem yourself is to have your trial and have it done fairly. And in this case, when we look at the evidence, 6 witnesses, and we look at the standards for unanimity, there's no way, there's just no way the government satisfied those standards. And even worse, look at the extensive, pervasive, devastating hearsay that was presented in the form of Ms. Stanley. That continued like a runaway freight train over sustained objections. And the government, you know, profited off of this improper testimony. And going into that issue very quickly, it's not simply cumulative, because she said much, much more than MJT or KRF. She gave much more detail, and she was much more damning in her testimony than the 2 alleged victims. It's not cumulative. It was pervasive, unfair, and harmful. And that's the reason why the conviction regarding MJT should also be reversed, because everything together is tainted. So if there are no other questions, then I would resume.
I thought you were not challenging the convictions of MJT.
I am. I'm not challenging it on the basis of sufficiency, but I am basing it on the hearsay issue.
And that's predominantly because of Officer Cruz's testimony?
And the mother. I tried to highlight the mother's hearsay testimony. She gave extensive testimony regarding MJT also.
Wasn't MJT's testimony, sufficient alone?
I would argue that I agree. From a sufficiency point of view, yes, it was sufficient.
Yeah. So if the mothers potentially could have just been cumulative then of MJT's evidence, and as far as Officer Cruz's testimony, there's an argument that the defense counsel opened the door because he was the one who brought up trying to impeach him about the number of instances that had occurred.
Yeah, I see that argument, and that doesn't really apply to the KRF.
No, I understand that. But that's why when you said you were challenging MJT's conviction based on the hearsay, I think it's a much different situation than KRF's.
Right. MJT was, there was only one count as to each of the 2 charges. So that was much more focused. And he did testify to the contact with the anus and the penis. So from a sufficiency standpoint, we didn't argue that. But from a hearsay, and I don't think that this can simply be dismissed, Your Honor, as cumulative, because the mother's extensive testimony was damning and prejudicial. She said much more.
But why wouldn't it be harmless if his testimony alone, and we've said, is sufficient to sustain the conviction? Because
the jury in evaluating the evidence, might have been uncertain about the credibility of MJT. He was 4 years old at the time of the allegations. And when you have the mother coming in there and reinforcing his credibility in that way by repeating, she said, I learned that Mukai had penetrated MJT. He touched them. He threatened to hit them. He threatened that if he went to jail, he would die and come back to haunt them. He threatened that if they told me, he would hurt them. I learned he held a knife to my daughter. He made my children shower together and touch each other. I learned that it was possible that he may even have touched my younger child. But KRF and MJT both shared with me, and I learned that Mukai and then KRF also gave me a note that she was too scared to give me. She said he was sexually assaulting them. She said, how are you going to hurt my children like that? She said it was happening weekly, often. My children felt like it was happening almost every day in a sense. That her children had severe trauma. They had severe PTSD. They had been diagnosed with anxiety and PTSD, the underlying trauma, the sexual assault from Mukai. Her testimony is just extensive. So how can my client have a fair trial when this improper testimony is just, is bombarding the jury? So that's why the MJT conviction should also be overturned. It's just not a fair trial as to MJT. And overall, there should be a new trial in this case.
Mr. Paris,
Yes, Your Honor.
in the second charge, there's only one instant charged, right?
Correct.
So doesn't that take care of the Sixth Amendment argument about non-unanimous jury decisions?
Well, which instance are they unanimously agreeing to when the
Well,
victim said?
if they convicted him of the second charge, which appears to be the Anderson Air Force Base residence,
Mhm.
well, there's only one charge there, so there isn't an issue about unanimity.
If the jury was able to separate out that as a specific instance, but when we look at the evidence and the 6 witnesses, did the government substantiate that? And would the jury have been able to make that determination unanimously based upon the evidence presented? And I would submit no. The fact that the government charged it that way, just because there's a conviction, does not mean that the unanimity requirement was met. It doesn't matter that the jury was polled and said that that was their verdict. It doesn't matter. What matters is what was the jury presented with and how could they have applied it? And based upon what was presented, there was no way they could have unanimously agreed to even the second charge because of the way the case was presented. If they had presented it in a way where she said, he stuck his penis in my vajayjay one time and it was at the Anderson location, then that would be different. But when she's non-specific, then the jury unfortunately could not unanimously find a specific instance. What it appears in this case is that they simply took the evidence and said, okay, the statutes must have been violated, so we're going to convict without coming to unanimous agreement regarding the underlying factual principles.
I understand your argument about the mother's hearsay, but she also testified about her observations of the children at certain times and how their demeanor changed, their attitude changed. Doesn't that give the jury evidence from which they can infer the date where things may or may not have happened based on the change in behavior?
Yes, as to KRF though, but as to what things? As to oral sex, as to hand, or as to, as to what? Why did it change? They can't speculate. What and why did it change? And okay, let them infer that, but aren't they tainted by her testimony about the PTSD and the severe trauma? What basis does she have to say that? She's not a medical expert, and she's basically running free, unrestrained, talking about these allegations to the jury. I'm not sure if I answered the court's question, but okay, take that as, and you don't need corroborative evidence. I understand. Yes, the jury can take that, but how do they apply it? I mean, basically, they have to come back and agree to a penetration or a contact. They have to agree to specific. They have to agree to 7. And she said, the alleged victim said, it's impossible to say how many times. And when she says 10 or more of what? Oral, hand, contact, it's non-specific. Jury would have to speculate.
Yeah,
Send this case back.
But the indictment, Mr. Perez, only charged sexual penetration. So if there's evidence that there was penetration, there was only a single manner in which, and now if the victim testifies as to different ways in which she was sexually abused, that doesn't foreclose the government from charging just a single manner. And so long as there's testimony to that effect, they have seemingly satisfied the requirements under the statute.
They should have just charged 1. They charged 7. They charged 7 penetrations and 7 contacts. They should have just charged 1.
I will allow you to reserve your remaining time. You have little less than 6 minutes, and we can get back to this and in reference to Justice Merriman's point that charge 2 and the single act. But at this time, Assistant Attorney General Wallachuk, you may unmute yourself and you're recognized.
Chief Justice, and may it please the court. The defendant in this case is blaming everyone for his predicament but himself. Mainly, he's blaming the victims for the ordeal that he put them through, especially KRF, who was just a little child at the time. The people intend to show today that he has no one but himself to blame. I will address the issues in the order that they were presented by the defense, and if there's time, I will get to the last one. So that would be.
Can I ask,
yes,
what
yes.
were the incidents that you believe the jury convicted on? She had testified based on her testimony. She testified that he put, his penis in her vagina, made him perform oral sex, and it happened more than once, more than 10 times. The indictment doesn't mention oral sex, although oral sex could fall under the definition of sexual penetration and sexual contact. The indictment is very specific on the second degree of causing the penis to touch the primary genital area. So it seems like her testimony to oral sex isn't consistent with the specificity of the indictment regarding primary contact, penile contact with the primary genital area. So what were the 7 instances that of first degree and the 7 instances of second degree that you believe the jury found?
All right, yes, Your Honor. When KRF was describing how she was assaulted, she said Mukai would do this and this and this. He would do this. So it was like he had a routine. He would undress her. He would make her do things she didn't want to do. He would touch her all over. He touched her bottom and her, she called them chi-chis at the time, by which she means breasts. And he touched her vajayjay, by which she means vagina. And then she said he would rape her, which means he would put his penis in her vagina, and also he would force her to perform oral sex. So she said this happened many times. When she says it's impossible to say how many times, that doesn't mean it never happened. It just means that she can't tell you exactly how many times. And I would remind the court that
and I don't think there's a dispute about that. The dispute is distinguishing between how many times there was oral sex versus how many times there was penetration versus how many times there was primary contact with the genital area, penile contact with the genital area, because the indictment doesn't mention oral sex at all, and is very specific as to what the alleged act was.
yes, that's right, Your Honor. What I'm trying to say is that he had a routine of all these acts that he would go through, and just because he performs other acts doesn't negate the fact that he performed the ones that are charged in the indictment. And that doesn't take away from jury unanimity, as long as they can agree to all the acts that were testified to, and there's a general instruction about unanimity. We are not limited to just the acts. We're not limited if the witness testifies to more acts than were charged in the indictment. As you know, these witnesses are testifying 10 years after the fact, and the indictment is based on things that are in the discovery. And we can't predict what little children are going to say 10 years later. So there's no way for us to whittle down 7 to just 1 or 2. If the discovery shows, yes, Your Honor.
You can do that at the close of evidence based on the proof. So don't say
Yes.
you can't whittle it down.
That's correct, Your Honor, except in this case, the little girl testified that there were more than 10 instances. So she told us how many
Instances of
times
what?
this
You're
happened.
saying in every instance, all these events happened?
Yes, Your
That,
Honor.
is that the position that you're taking? So when she said more than 10, that penetration happened, oral sex happened, primary contact happened?
Yes, Your Honor, because when she testified, she said that, Mukai would rape her when her mom went out. Her mom went out at least 6 times a week because she was a runner. So she would run at least 6 times a week. She would also leave him to babysit when she went to run errands and when she went out on a weekend night. So these are things that happened while she was out. And that's why we say that, there's enough instances of this happening for that to support the convictions in this case. I'll just go over the sufficiency of the evidence. So I'll just point out, as your court has noticed, that the defendant is not challenging the sufficiency of the evidence as to MJT. As for KRF, she testified herself that these things happened in Guam and it happened in both houses. And the mother is the one who established when they lived where. So at a very minimum, you have at least one instance of penis and vagina sex and penis contact to genital area contact. You have at least one instance of that at each address. So I would submit, Your Honors, that there's enough evidence to at least support that and the jury unanimity as to that. But there's also enough to support more because she testified that it happened more than 10 times. She said it happened a lot, and impossible does not mean 0. As for the as for the defendant hurting her, I know that the defendant raised this issue that we didn't specify how he was hurting her. She testified that he was hurting her because he had sex with her. And the little boy also testified that it hurt him when Mukai was molesting him. So even though that's not an element that we need to prove, there is evidence of that. Plus the sane nurse examiner established that KRF said that he put his penis in her vajayjay. So that also establishes an instance of penetration. As for unanimity, these other acts, they are intrinsic to the charged acts. So this goes to the questions that the Chief Justice was asking. These little children, after so many years, are testifying to more generic testimony because they're not able to recall the exact dates. But the defendant has enough notice if the children can testify to the time period more or less and the location and the acts that happened to them, that the defendant did to them. So in this case, we do have that. We have the kind of act, the number of acts, the general time period. The time period is tied to where they were living, and they both said it happened at both houses. And the kinds of acts, the little girl testified to what kinds of things she went through, and so did the little boy. And as for the number, he said, I think one of each, at least, when he testified, and she said more than 10. Actually, the little boy even testified to more. I think he also said more than 10, but the defendant was only charged with 1. The defendant's defense here is not alibi or mistaken in identity. He's only arguing actual innocence. So for these witnesses to be more specific, that doesn't help his defense. So there's not a material variance between the charges in the indictment and the proof of trial, just because KRF testified to other acts during the relevant time period. You only get reversal of the conviction if there's a material variance, which is something that takes the defendant by surprise and prevents him from defending himself against the charges. Here, it's just a mere variance, and therefore it's harmless. The jury was unanimous, and his convictions should be affirmed. As to the hearsay, in the Rotten case that this court has decided, the hearsay has to be such that it changes the outcome, so that we would not have had this outcome if the hearsay had not got through. And in this case, the children testified to acts by the defendant, which are evidence of the charges beyond a reasonable doubt. And the defendant had leeway to cross-examine them beyond the scope of direct because the witnesses were going off island after they testified. So things like the SCX comment, the defendant brought that up himself. When the prosecution first brought it up, the defense objected and the court sustained it. But then the defendant brought it up too and did not object to his own comment. So I think the trial court may have rethought sustaining that objection because it was not offered for the truth of the matter. This SCX comment had to do with something that Mukai was talking about at the dinner table. He could have been talking about anything. The reason that this SCX comment had such an effect on the mother is because her little 8-year-old girl was saying it, and that's why the mother ended up doing all the other things she did, which was confronting the little girl and then the little boy, having an outcry, and then later on calling the police, having the defendant ejected from the home, going to see the investigators, going to Healing Hearts with the little girl. So this comment is what precipitated all the things that came after. And in the defendant's opening statement, he says that the jury has to decide if the witnesses are credible and do they remember better now or then. And this seems to be aimed at the children's testimony because their minds are less developed. So it makes sense for the mother to testify as to what happened, because that establishes how the events were put in motion, after the outcry, whereas the children don't seem to have much memory of that. Also, some of the objections were sustained. And so if the mother kept testifying to it, why didn't the defendant move to strike it or demand some sort of curative jury instruction? Maybe the defense had some sort of strategy for that. And if that's the case, then this is more of a subject for a habeas action because it's not necessarily an effective assistance if counsel had a good reason and a strategy. So even if it was error for the trial court to admit the hearsay, which we don't say it was, the hearsay is harmless because the jury was able to listen to the little girl and the little boy testify and could assess their credibility. Finally, the defendant raised some points about his upbringing and how his case was handled. We would submit, Your Honor, that the defendant's background, these are issues for sentencing, and the defense did not challenge the sentence, so these arguments are waived. Also, I would point out that the defendant did get his first appeal. He did have his convictions reversed. He did get an expert appointed to him, and he did not even call that expert at the second trial. Plus, all the experts had created reports, and those reports were submitted to the court at sentencing. So these reports are actually something that caused the people to ask for more time because they showed how manipulative the defendant seems to be. And that's why maybe the trial court gave a higher sentence than the first trial court, but less than what the people were asking for. So in conclusion, Your Honor, we ask that the court affirm the defendant's convictions and the judgment below. Thank you.
Now, Ms. Wallace-Chuck, in listening to the various arguments, Mr. Paris points out the concern for due process violations and reference to a unanimous verdict being required as a constitutional right, and the nature of the evidence here in terms of the generic testimony of child victims. Does this circumstance call out for a legislative resolution, like other jurisdictions where they have created a continuous course of conduct crime? That we've seen that in other areas in reference to the exception being created, and so that there can be a proper balancing of the respective interests. As Mr. Paris has pointed out, he is in no way arguing that this type of activity should be immunized, and that a defendant, not an alleged child molester, not face criminal prosecution. But there are constitutional rights that are allegedly being violated in prosecuting these type of cases. At least the argument is in terms of due process violations. California has created a specific statute that makes it a crime in reference to these circumstances, and they're a continuing course of conduct. Is that a better remedy in trying to create some rule that was very difficult? You just probably need to take one side or the other in reference to providing a case remedy for these type of cases.
So, Your Honor, a legislative solution may not be out of the question. It may be more helpful. However, the court can also make law. It can make case law based on what other courts have done. There is no due process violation if there are uncharged acts, as long as the defendant has notice and he can prepare his defense and there's a unanimous jury, which is everything that happened here. There is nothing more that could have been done for this defendant. I don't think his rights were violated. So while a legislative solution is, it may be nice, but it's not necessary for this case to be decided. This court can decide this case based on the case law alone.
All right, thank you, Ms. Wallace-Chuck. Mr. Paris, you have a remaining time. I think it's a little over 5 minutes.
Thank you, Your Honor. I just want to make some quick responsive points. The first is we're not saying that the evidence was generic. We're just saying it was insufficient. What the government should have done was indict the charge or charges they can prove, present the case fairly, meet their burden of proof, and don't try to simply convict, but to seek justice. And the fact that we've got minor alleged victims and the passage of time does not change these standards. Those standards are there for a reason, and they should be enforced. I don't think we need new laws. We have laws in place. They just need to be followed. And our argument on appeal is that these laws were violated, specifically the Sixth Amendment, the hearsay rule, and that the government did not meet its burden of proof with respect to what it presented. We think this case really should be sent back for a new trial. The fact that we did bring up some background issues, it's not for purposes of raising different legal issues, but simply to highlight that sometimes you've got vulnerable defendants too, and defendants are presumed innocent unless they're proven guilty beyond a reasonable doubt by the government and a jury. And Mr. Callahan, I'm not trying to say, I'm not trying to focus on him as being a victim, but we do have somebody who was quite young when these allegations were charged against him. He was 16. He was basically a foster child, a product of the foster system. And there's indicia of him also having been victimized. So I bring it up for the point that the government should not be casual with his or anyone else's rights. And we see that in this case, there have been instances where his rights have been disregarded, but then observed by this court. And we think this is another example of where we're asking this court to observe rights that have been violated. And with respect to Justice Merriman's question, I just want to go back to that regarding the fact that the jury unanimously found count 2. I went back and looked at the government's recitation of the testimony from KRF and from the mother, and I don't see, just like in our own statement of facts, any witness connecting the penetration that was testified to the second charge. And I reiterate that I think that it would have been impossible for the jury to unanimously find that without there being testimony that he put his penis in my vajayjay within this time frame or when I lived at this location. Because otherwise, which time frame is being discussed, which location is being discussed, and that level of specificity is required when the government is alleging those in an indictment. I really ask this court to send this back for a new trial with where hearsay is not coming in and where, maybe the government should really reform its indictment and charge what it can prove and not overreach. Thank you.
All right, thank you, Mr. Paris. Any further questions?
None.
There being none, we thank you for your arguments. The court will take the case under advisement, and we now stand adjourned. Thank you, counsel.
Thank you,
Thank you.
counsel.
Thank you, Your Honor.